Ready? 10:05.
Are you ready, Professor?
I'm ready when you are.
Okay, well, first of all, thank you very much to all the attendees of this event. My name is Camilo Andrade. I am an associate attorney at Olarte More, and we are very happy to have this special guest today. Let's briefly introduce her profile. Professor Rab is a barrister at several court chambers in London. She has been practicing in the area of competition law for more than 20 years. Professor Rab was previously a solicitor, and she has been a partner in a U.S. law firm. Professor Rab is a professor of commercial law at Brunel University in London, and she does a lot of work traveling around the world, teaching and advising governments and organizations, helping develop competition law policies in places and economies where competition law is not developed. Professor Rab is committed with the academic community and public policy, and that's basically the reason why I met her almost a year ago. She came to visit us here in Colombia, and she made 2 presentations at 2 universities. I attended both events, and I consider there were 3 main reasons why we, as Olarte More, wanted her to participate in this event. First, because she is an expert on competition law. Second, because she has been working in highly regulated sectors. And third, because she is the coordinator of the Brunel Competition Law Summer School in London, which she will be explaining at the end of the session. Before I stop talking, I want to ask you to please send your questions on the chat. And at the end of the session, I will be reading the questions to Professor Rab. Professor Rab, having said that, the public is all yours. And once again, many thanks for being here with us.
Thank you very much, Camilo, and thank you, Olarte More, for inviting me to deliver this presentation. It's an honour and a privilege to do so to an international audience. I believe we have participants from South America, from the United Kingdom, from Dubai, and also as far away as India. So good morning, good afternoon, and good evening to everybody. I will start by sharing my screen with you. I would just like my administrator to allow that function, please, to allow me to do so, so that I can confirm that that function is available. Maria, could you just activate the share screen function for me, please?
Yes, Professor. Freddy, ¿estás en línea?
Sí.
¿Nos ayudas, por favor?
I believe that the function is
compartir
disabled.
Ok,
Gracias.
listo.
Could you please try now, Professor?
I think now you can share your screen, Professor.
Right, so
Yes, perfect.
welcome to this session on competition law in challenging times. So as the United Kingdom enters what is our 7th week now of lockdown, it's an important time to reflect on how competition authorities, and particularly in the UK and in Europe, have reacted to the challenges presented. We've seen a relaxation of some aspects of competition law, but also a toughening in some other areas as regulators grapple with the tension that practices such as coordination between competitors, which would usually not be permissible in more normalised times, may be necessary to ensure effective delivery of supplies. So what I will do in this session is reflect on the response of the UK regulators, principally the Competition and Markets Authority, which is the competition regulator in the United Kingdom. I'll also reflect on the approach of the European Commission on a pan-European approach. At least until the end of December 2020, the UK will remain subject to EU law in the area of the level playing field, which includes competition. So, subject to any extension of that, the UK faces dual regulation here on the part of the European Commission in respect of competition matters, but also by the national domestic regulators. If we look at how the Competition and Markets Authority has approached its task, we can identify strands in terms of changes to the procedural and institutional arrangements, and that includes the creation of a special COVID-19 task force, also changes in day-to-day business operations, and there has been an inevitable impact on the ongoing case law. So very early on, as early as the 20th of March, the CMA set up its dedicated task force, and this is tasked with analysing market developments which may uncover harmful pricing and sales practices. We've already seen firms increasing prices for certain goods such as sanitisers and personal protective equipment, and the CMA have sent a strong message that firms suspected of exploiting the situation will not escape competition law investigation, and there will be enforcement action if firms have failed to respond to warnings or are in breach of competition or consumer protection law. And this is where the CMA also has a consumer protection role in addition to its competition role as regulator. And this task force will also equip the authority to be ready to advise the UK government on any emergency legislation that may be necessary to stabilise a situation of increasing consumer anxiety. And we did see early on in March consumers stockpiling goods, concerns as supply chains reacted. That has now thankfully stabilised, but it was due in no small part to agile reactions on the parts of business and regulators to manage that situation. We've also seen changes to day-to-day operations. Like many businesses and regulators around the world, the offices of the authority are closed. They're not accepting delivery of documents in the normal way, and employees are working remotely. All hearings that would otherwise take place at the CMA's offices are being conducted remotely where possible. And I've certainly had experience of online hearings with regulators and courts, and also conducting online mediations in these more unsettled times. The CMA has said that responses and resources will be allocated to prioritise the most urgent and most critical cases. Interestingly, when it comes to merger review, the CMA has said that that should proceed according to normal administrative timelines, but inevitably delays can be expected in respect of third-party consultation. The UK has a voluntary merger regime, which means there is no obligation to inform the authorities either in advance or after a merger has been completed. So the CMA does not face the same challenge of other authorities, such as the European Commission, who operate in the context of mandatory merger control, where mergers meeting the notice notification thresholds need to be notified in advance. So that may explain the more flexible approach of the CMA in this instance. When looking at the ongoing casework of the Competition and Markets Authority, it's interesting that there are a number of high-profile projects which are now proceeding on a different timescale to that which was anticipated before the COVID-19 outbreak hit its escalation point in March. So an important project was the creation of a digital task force which was tasked with examining the challenges to competition presented by digital platforms, and only announced on the 11th of March. This is now still treated as a priority area, but without the face-to-face hearings that were expected in the early stages. The UK also has a market investigation regime which is quite unique internationally, which allows it to investigate particular sectors even where individual companies are not suspected of breaching the law. Before the outbreak, there was an investigation into the funeral market sector, and the statutory deadline for responding to that has been extended by 6 months, inevitably recognising that this sector is very much in the eye of the storm. Turning to substantive competition law enforcement, and there are perhaps 3 broad strands here. We see a targeted but very partial and focused relaxation of competition law in some areas. The CMA has also issued specific guidelines on where its enforcement priorities lie at this time. And it's issued bespoke guidance on how it applies certain exemption criteria in cooperation cases. The cooperation background is very important because the strict position under both UK and EU law is that a restriction of competition may still be compatible with competition law if, on a balancing of efficiencies, necessity and translation of those benefits to the consumer, nevertheless there is a pro-competitive outcome. And the CMA has issued specific guidelines on how it will approach that assessment. So early on, the CMA recognised that there would need to be some flexibility to allow cooperation between essential businesses. So supermarkets were allowed to join together in a clarion call to feed the nation. This allowed them to share certain information on stock levels, to keep the stores open and to share depots. And now we see quite a lot of flexibility where vulnerable groups are given dedicated times of the day to shop, and there is a much more rational approach here, which has instilled a lot more calm in the approach to daily shopping. But at the same time, consumers have to observe a 2-metre rule, which has become a working practice, not one mandated by government authority, but one which makes sense in the current environment. Healthcare providers, again, are allowed to work together to share essential information where that's necessary in the context of managing this situation. There's also been a relaxation of the rules to allow ferry operators to continue to operate on essential freight and passenger flows between the Isle of Wight and the United Kingdom to ensure that those transportation routes remain open. When it comes to guidance on the CMA's enforcement priorities, the starting point is that it does have an administrative priority approach. It cannot take on every case and prioritises them according to need, evidence, cost, resources and the consumer welfare impact, amongst other considerations. And the CMA has recognised that in this time, competition law enforcement, if applied in its strict rigours, could impede necessary cooperation in essential supplies. But it's made very clear that this is not a free pass to businesses to flout the rules. So its approach is built around prioritising cases, but also a dedicated approach to that exemption criteria approach for justifying otherwise restrictive behaviour. And that's treated under our Chapter 1 prohibition under the Competition Act, which is equivalent to Article 1013 of the Treaty on the Functioning of Europe Union, and national law equivalents around the world, including in Colombia, Brazil, and India. When it comes to the CMA's approach on the exemption criteria, it's emphasised that cooperation will need to be efficiency enhancing, likely to benefit the consumer, and needs to be reasonably necessary in the circumstances. And this takes place against a background where it's important to react in real time because of the limited opportunities to consider alternatives. But it's very much a risk assessment. There is no facility for businesses to obtain upfront clearance from the authority that their practices are acceptable under competition law. But it's expected that at least collaboration to ensure continuity of supply and scarce resources and essential services should be permitted. When it comes to merger control, we're seeing some interesting cases where the CMA has had to apply its merger control substantive assessment in the face of claims of failing firms or even flailing firms, which might otherwise go out of business were it not for the merger. These defences have not always been raised in quite those terms. So in the Amazon and Deliveroo case, which was an investment by Amazon into an online food delivery platform, Deliveroo, it was observed that Deliveroo will be forced to exit the market absent the merger. And the fact that many restaurants and cafes were closing as a result of social distancing measures impacted upon its revenues and long-term sustainability. Another merger in the sector between Takeaway and Just Eat, which was cleared at the end of April, did consider whether there was a realistic prospect that the acquiror, Takeaway, would re-enter the UK market as it had previously exited. But the competition authority found that there was no such prospect and cleared that deal 26 days in advance of the statutory deadline. But this is not to say that all deals which would otherwise be difficult in more normalised times will be given a green light. And the CMA has emphasised the importance of assessing the relevant counterfactual, or the position that would exist absent this particular transaction. So slightly different from a counterfactual of assessing with or without the merger, because the question can very often be, is this merger the least anti-competitive of all other options on the table, of which the current deal may be the only viable one? And that outcome may be less anti-competitive than allowing the target to disappear completely. In the United Kingdom, we also have a variety of other regulators that are charged with specific sectors. They also have competition law enforcement powers, which they share concurrently at the same time as the CMA. So our Communications Authority, Ofcom, and our Energy Authority, Ofgem, have signalled that they will take a pragmatic approach to enforcement in respect of their sector responsibilities as well as competition law in these more unsettled times. But again, expect delays. They have delayed some consultations that were more business as usual in order to prioritise more urgent and pressing matters, and suspended policy publications to ensure continuity of supplies to consumers in what are essential services. The Water Regulation Authority, Ofwat, has written specifically to its regulated firms to encourage sector-wide responses, and it has also suspended its penalty regime for wholesalers and retailers that are found to breach industry standards. So a more moderated approach, a more targeted approach, but still recognising that regulatory and competition obligations remain in these difficult times, and that there is no excuse for businesses flouting the law or who otherwise exploit vulnerable consumers. Cooperation is always a difficult area in the area of competition law, where practices which initially do restrict competition do need to be justified on a balancing of effects and countervailing benefits. If we now turn to the response of the European Commission, which currently operates a pan-European approach to competition law under the Treaty on the Functioning of the EU, and that operates in parallel with domestic enforcement regimes at the national level, including for now the United Kingdom. Three strands I'd like to cover: guidelines for collaboration, the area of state aid, which may not be as familiar to international viewers as it is to European viewers, but very broadly, any state support or financial assistance that favours particular companies and restricts or distorts competition and cross-border trade needs to be notified in advance to the European Commission before it has been put into effect, unless an exemption or a framework applies which dispenses with that obligation. So that is a very stringent approach to subsidy control, which is brought very much into the spotlight in the context of ongoing stimulus and support measures by member state governments. Usually these measures, if notified, would take up to 2 months to approve, if approved at an initial stage, or potentially longer. So there are very obvious tensions in terms of putting support measures in place with agility whilst business and economic circumstances are experiencing real stress in real time. And the European Commission has also adopted specific filing arrangements with regard to its mandatory merger control regime. So some similarities with the UK, but also some nuances and differences. So the guidelines on collaboration were issued at the beginning of April and explain how the European Commission will approach essential business cooperation, a very similar analytical approach to that of the Competition and Markets Authority. But what is interesting is setting up of an exceptional procedure which will allow business to obtain ad hoc comfort letters on specific cooperation projects. It's by no means a green light to those projects, but it does give a level of assurance. For those competition law veterans who have been advising in this area for some time, you may detect a similarity with the approach to comfort letters that ended in 2004, and I must count myself as one of those. Back in that time, it was possible to notify agreements to the European Commission using a Form AB. If that didn't result in an exemption decision, it was open to the European Commission to issue one of these comfort letters. That was all swept away in 2004. I doubt very much that this measure will be a return to those times, but it will be interesting to see how, on a temporary basis, that route will be used by businesses to obtain at least some level of comfort that some more difficult collaboration projects are compatible with EU law. When it comes to state aid, the Commission approved its first measure as early as 12th of March. This was an approval of 12 million euros of aid given by Denmark to compensate businesses for cancellations of large public gatherings that couldn't take place as a result of COVID-19. That was approved within 24 hours. And it's a reminder of similar flexibility and agility that was shown during the 2008 crisis, when measures need to be approved overnight over a weekend in the face of the collapse of financial institutions. The Commission used a provision under the treaty which allows member states to compensate companies or sectors for damage caused by exceptional occurrences. It's interesting that this event was not possible to reconcile with our general block exemption regulation, which allows compensation and support to be given in the context of a natural disaster. COVID-19 was not treated as such, and that's what made an individual notification necessary. The Commission shortly followed with a temporary framework, an umbrella-like provision to allow state support to be given without the need for notification, a variety of different support measures such as grants, guarantees and subsidised loans. That measure has since been extended and will remain in place at least until the end of the year, and it may be renewed. But up to now, the Commission has resisted pleas from some member states, including Austria, to temporarily halt the state aid framework and allow member states to grant assistance without needing to satisfy themselves that there is an available exemption or make a notification where necessary. Similar pleas were made in the financial crisis in 2008, are similarly resisted. The argument being put forward is that the delay that may take place from approving a measure to it being put into operation could be very damaging to businesses who may not survive in the interim. In defence, it's been said that it's not been the fault of the Commission that has actually prevented assistance being dispensed, but more due to delays at the national level. So far, an attempt to completely suspend state aid rules has been resisted. It will be interesting to see how the UK's own state aid regime, which is expected to come into force at the end of the year or the end of any extended transition period, how that would fare in similar circumstances. The CMA has already built up significant capacity in getting together its own state aid team and is poised to implement a subsidy control regime once the United Kingdom is free from EU law, and that is certainly expected to take place whether or not any future trade deal is concluded with the European Union. So very much watch this space in terms of the UK's own developments in subsidy control. And I do have another video podcast that I'm very happy to share with viewers if you're interested in that area. As I mentioned, with regard to the UK's merger control regime, the European Union operates a mandatory merger notification system. That means that mergers with a union dimension, i.e. those which meet the worldwide or national turnover thresholds, need to be notified and suspended pending a review by the European Commission, and only then can they be implemented. The European Commission has asked businesses to delay filing where possible, and it anticipates complexities and disruptions given the potential deluge of notifications, whilst it's also dealing with the challenges of COVID-19 related issues. As one would expect, it's operating remote working for most staff, and in-person meetings are on hold. And I attended one of the last in-person meetings in the week before these measures came into place, and it had very much an end of term feel to it, and in anticipation of these measures which were about to be put into place. So the Commission does remain open to dealing with urgent notifications, but recognising the increasing constraints on its systems. So drawing together some of the emerging conclusions here, and this is very much an area which continues to evolve on a daily basis. So we've seen how the pandemic has necessitated a targeted relaxation of competition laws, but a toughening up in some areas, particularly abuse of market power, where businesses certainly will have no excuse for using any market power to distort competition by excessive price increases or withholding of supplies. And cooperation will be justified only where it is necessary, and this is a partial and temporary relaxation, and certainly not a get out of jail card for businesses who would engage in collaborative action and which would harm the consumer. And all authorities around the world have emphasised that now more than ever, competitiveness will be important, not only to dealing with the public health crisis, but also getting the economy back on foot. We've seen similar approaches by the United Kingdom, the UK sector regulators, and the EU, but inevitably those are coloured by their own procedural and institutional frameworks, so state aid and merger control being an important area of distinction there. This is a difficult time for businesses, for their advisors, and for regulators. It will certainly see a lot of stress testing of business efficiencies and business models. This experience has taught us all that old ways of working are probably not going to be sustainable business models going forwards, and there will be casualties of the system. The challenge for the competition authorities is to continue business as far as usual as it can do so, but to put business and the economy and consumer welfare back on track. So interesting times we live in, and perhaps now more than ever, given this more nuanced approach and sharing of best practices, it is important to look very carefully at the area of competition law and competitiveness, given what is very much an evolving landscape. If you'd like to discuss these issues in more detail, please don't hesitate to contact me Suzanne Rab at Searle Court Chambers. My details are on the screen, and I very much hope that we can continue this dialogue virtually or potentially face-to-face at some future date. At the outset, Camillo mentioned that I am also involved in a number of international developments and activities. I work with universities, regulators, governments and businesses around the world to share best practices in the area of international competition law enforcement. That includes South America, North America, Africa, Europe and Asia. And as part of this, I've developed an international summer school. Unfortunately, this is not taking place in 2020, given the very understandable constraints of the worldwide pandemic. But we are looking very much forward to the next presentation in 2021. So I'll take a few moments now to share with you all a few thoughts on the growing internationalization of competition law and give you some insights into that particular course and hopefully whet your appetites with some enthusiasm for this interesting area of practice. So I am now hopefully sharing my screen with everybody, and you can now see my second presentation, which will briefly cover the Brunel Comparative Competition Law Summer School. I do have quite a detailed presentation here, which I won't cover in quite as much detail as is on the slides, but I'm very much happy to share some of these thoughts offline with individual participants if that would be of interest to you. But clearly, with over 100 countries now having competition law, and many more are planned and in operation, that includes the competition regimes that are already very much entrenched in Latin America, in Africa and in Asia. It's interesting to see how many of these regimes have drawn their inspiration from the more established regimes, but each brings with it specific features. And certainly my guiding principle has not been one of copycat or blueprint or export of models which have worked in some jurisdictions and to see those as the necessary benchmark in others, but to recognize that we can all learn from each other through a sensitive approach and sharing of ideas. So clearly competition law enforcement shows no sign of relenting, and I've shown on the screen here some big cases in the EU, many of which have counterparts in jurisdictions around the world, with Google under the spotlight and multinational cartels such as the Marine Hose cartel investigation, which I participated in as advisor and which covered numerous jurisdictions around the world, from Brazil to Australia to the EU and Canada. So why should we be interested in competition law right now? What does the summer school have to offer? And then I'd like to open up this presentation to Q&A. So as we've seen, most countries internationally have competition law, and there is many more in the pipeline, with inspiration being drawn from elsewhere. But there are nevertheless key differences. So a key question is how much consistency is attainable? My inspiration to become a lawyer perhaps colours my approach to internationalisation of competition law. And I may live in the United Kingdom but both my parents were immigrants. My father came from Asia and was very much inspired by the use of law to improve consumer welfare. That got me very much interested in competition law, which is fundamentally about how businesses operate, and ultimately its goals, certainly in Western economies, are to protect or promote consumer welfare. So back in my university days, which are some time ago, I did study competition law, and that's what inspired me to pursue this as a career. You may think I look very, very similar to how I looked over 20 years ago. I will leave that to viewers to decide. But certainly echoing the comments of the European Competition Commissioner, what is at stake here in competition law is something very old and very basic, but what this area tries to weed out and to tackle is a situation where markets do not actually deliver good outcomes, and ultimately regulators do need to step in where the pursuit of profit and greed may lead to outcomes which are not efficiency enhancing or in the interests of the consumer. So the various competition law building blocks will be familiar to the competition law experts who are tuning into this session. I won't go through these in detail, but the key planks around anti-competitive agreements, abuse of market power, sometimes called dominance in some jurisdictions, and merger control are the key planks which are common to jurisdictions around the world. There are some others, such as state aid, public procurement, which may have a specific national law flavour, and as we've seen, that is particularly characteristic of the approach in Europe. Some of my competition law clients are from around the world, and just a few examples are from as widely drawn regions as Pakistan, North America, India and South America, as well as China. So very much an international framework in which I operate and in which competition law does. It's an area where I have written books on international competition law and regulation, drawing on best practices and contrasting themes. And these have been inspired by my work with newer competition authorities and in regulated sectors, including in the media sector. There are inevitably development challenges for newer authorities. They have to tackle limited awareness at the outset. There may be high levels of market power and uncertain and difficult regulatory criteria to apply in a legal system which has not yet dealt with competition law, which is founded on economic principles. There may even be a culture of bribes or facilitation fees in order to secure contracts, which is the absolute antithesis of free competition. So these are challenges that all new authorities will face, and even some more established ones continue to face this in certain industries where hard habits die very slowly, such as construction or chemicals or other mature industries which display homogenized products. It's an area which is very high profile in the news, and I'm often invited to speak at news events, and that includes through BBC TV news interviews and other media fora. So very much in the spotlight as an evolving and growth area. So the Comparative Competition Law Summer School seeks to bring all these themes together with a 2-week international program, which certainly we at Brunel believe is unique around the world because it draws together insights not just from Europe, but from Asia, Latin America, and Europe. And these impacts will be explored not just on a sector-neutral basis, but in particular areas that have attracted scrutiny, such as financial services, energy, media, healthcare, retail, construction, and others. New in this year, we'd introduced a program which would focus on Latin America and Africa, 2 jurisdictions and regimes which are quite different and have been less profiled in the international discourse on this area, and opportunities for delegates to have focused one-on-one telephone sessions with course faculty to discuss their feedback. The individuals who have been interested in this course over its last 3 to 4 years have been drawn from a very wide community, not just practitioners, not just academics, but regulators. Participants have come from in-house businesses as well as law firms, from Colombia, from India, Moldova, Nigeria, as well as the United Kingdom and Europe. And for anybody who wants to start from scratch in this area or build on existing knowledge, many of these participants do not have any legal training. Some may be economists or consultants in other areas of business risk. So there are 4 integrated courses. The first is built on EU and UK competition law. We have a practical skills component which will allow you to engage in mock trials, mock mediations, interviewing to put your skills into practice, but in the specific competition law arena. We look at international competition law from all the continents that I have discussed, and we will do a very deep dive into the media sector and how competition law and regulation interact in that space. The special features of this course reflect its cultural as well as academic focus. So in addition to classroom training, there are a variety of activities and interaction, visits to the Inns of Court, to my chambers. You will have the centuries-old dining experience at the Inns of Court and visit the historic sites of legal London when they are open. You'll visit the Supreme Court and have an opportunity to interact with peers from around the world. So it's very much beyond textbook learning. It applies my practitioner insights in these areas, as well as growing acceptance of competition law as an academic discipline and one built on strong theoretical as well as practical foundations. And through the practical skills training, you will get on your feet and be in a context where you can test your insights in real life. So through this combination of teaching and learning and interactive media, so we use video skills, we use simulations to very much make the program come to life. You will be evaluated, and if successful will receive 4 course completion certificates. So it's very much an investment in your learning going forward, as well as an opportunity for cultural and professional engagement. I'm often asked by students and academics or more junior lawyers why invest in something like this, and certainly there is benefit for people at all different levels in their career, whether they're just starting out whether they are mainstream litigators seeking a specific subject matter focus. So this will benefit all parties, whether you work for a government authority that touches around competition law issues or economic law, or you work as a regulator, or whether you're seeing this as a topic for PhD study. The Certificate of Completion Award will depend on satisfactorily completing the course as well as the moderated examination and of course attending it in full. And there is practical evaluation at the workshops. We do offer an international package for international delegates, which this year was priced at £2,600 for all courses. We certainly find that competitive with other offerings in the marketplace, some of which at other UK institutions, which are for a much shorter period, some half the duration of this course, are double the price. This includes the full 2 weeks of learning, which takes place across 13 full days, full meals and accommodation on site at Brunel University, as well as transportation on site and to the sessions in legal London, as well as the dining and visits to the courts and other historic London sites, and the course dinner at the end, which is a much welcome celebratory event. So to summarise, competition law is very much international and an opportunity for practitioners around the world, regulators, policymakers and governments to enhance and develop this area and share best practice. The course is a unique opportunity to share both legal and economic insights with experts, combined with cultural engagement in legal London and an opportunity to apply your learnings in practice. So very much more than classroom learning or something that can be gained from a textbook. It also brings to life real life insights from both academia and practical experience, not only of real life cases before the courts and regulators in the UK and EU, but from my international experience and that of other experts amongst my expert faculty, which are drawn from economics, from finance, from alternative dispute resolution. So I would very much have looked forward to welcoming you all on the June presentation this year. Sadly, that is not going to be the case, but I do very much look forward to welcoming at least some of you on our June 2021 presentation. We're already taking bookings and many of the participants for the 2020 presentation have automatically transferred to next year. So please, if you would like any further information, please do not hesitate to contact me, Professor Suzanne Rab at Searle Court Chambers and Professor of Commercial Law at Brunel University, London. Thank you very much for your time. I'm now going to stop my formal part of the presentation and I'm going to hand over back now to Camilo. If you could now moderate the questions, and I would be very happy to take any questions from participants. And that includes questions on the substantive area at the beginning and also on the competition law immersion course. Thank you.
Well, thank you, Professor Rab. I mean, definitely these are challenging times. We all are in lockdown and we see it in the news, everything that is happening internationally, and globalization allows us to be informed of everything that is happening right now and what is going on in Latin America, in Europe, and to have your input and your expertise is very important for us. We really appreciate your opinions, and this was really good for all the attendees and for the film. Thank you very much, Professor Rab. Now we have 3 questions from the attendees. The first question is from Maria Alejandra Donato. She asks if there is any price gouging investigation in course due to the COVID-19 in the crisis in the UK.
So by price gouging, I think we understand this to be an excessive inflation of prices for products. Now, we need to take account of the fact that that is a unilateral action by one business or a single business. So in the absence of any agreement on pricing, the only way that can be investigated is where a company is dominant in a relevant market and it is found to have been engaged in excessive pricing. So those 2 elements need to be established under competition law. The challenge here is finding dominance and whether the price is in fact excessive. So we do have anecdotal examples of companies certainly raising prices double, triple for certain goods, whether it's for a haircut or whether it's for soap or for masks or protective equipment. There is no published investigation underway in this area, but certainly the Competition and Markets Authority has emphasised that it will crack down on that type of practice and has set very strong warnings to firms who are exploiting the situation. It's also important that there is a consumer protection angle which is different from competition law and does not depend on a business being in a dominant position. So their consumer protection law obviously will operate where businesses are making unfounded claims about the effectiveness of their products. So the short answer is there is no publicised example of an excessive pricing case, but the UK, like other authorities around the world, Albania looked at a potential issue in this area but then did not found conclusive evidence, and that's probably because it is very difficult under competition law to establish dominance if it's a unilateral practice, and then to establish is the price excessive, because that of itself is an economics-based assessment. So just because a business is charging twice what it would usually do is not necessarily enough to found an excessive pricing case.
It's very interesting. Thank you very much. Well, we have another question from Juan Carlos Camacho. He asks, what do you think are the main associated risks with the measures taken by Ofcom and of what in regulated markets in order to protect vulnerable consumers?
Okay, well, this is an incredibly broad question. The questioner hasn't mentioned any specific measures that either of these authorities have taken. So I'm very much trying to answer this question with the best information that I have, nor have they asked me whether they are talking about specific measures taken in the context of COVID-19 or even more generally. And we have communications market and the water market. So my challenge here is, where do I start answering this very, very broad question in a way that addresses what the questioner wants me to answer? So let me just start by saying, at a general level, both these regulators have sector responsibilities where they can take measures ex ante before something goes wrong to protect consumers. which can be requiring the regulated company to provide information to customers, to give them information on where they might be able to get a better deal somewhere else. For example, telling them when their bill is about to change, or a fixed rate period, when they have an opportunity to switch. So there are a variety of measures that will be taken, other measures that will prevent these suppliers cutting people off if they can't pay. And obviously there are differences between an essential water supply and perhaps access to the internet. But obviously in these challenging times, access to the internet is a lifeline for most people who are socially isolated. So I think what I would say is that measures by regulators with using sector powers are very different from competition powers, which apply ex post, which is after some harm has materialized or is likely to do so. And many of the risks are that the regulator acts too early before there is harm, and that can be counterproductive. At the same time, if they do not act early enough, by the time the harm has materialized, it can be too late. So I think these are some of the risks. It's inevitably a trade-off for regulators, whether they use their ex-ante regulatory powers or competition law, which is ex post. And certainly in the UK, where Ofwat and Ofgem have both concurrent powers, like I mentioned in my talk, as well as competition power as sector powers, they have a duty called primacy, which says that they must, before they use their sector powers, they must consider whether using competition law is a more appropriate measure. So that is how in the UK we try to balance the risks and the harms of taking ex-ante measures under sector powers. So I hope that somehow answers that question, which was quite wide.
Thank you, Professor. There is another question from Margarita Romero. She says, I'm very interested in the course. I mean the summer class. They are online since this COVID crisis.
So the short answer is that the summer school of itself is not online. It's 2 weeks of dedicated physical interaction. So the course would not work if it was just purely online because of the cultural engagement. Having said that, I do have a number of other bespoke online competition law courses that can be delivered online using interactive virtual technology. I also deliver mediation training in the same way. So for the questioner who is interested in having some exposure to competition law in an online environment, please do contact me directly after this webinar for details and apply to Camilo for the best way to do that. But I will be more than happy to share with you what opportunities are available online.
For sure. Sure. Thank you very much. There is another question from Emilio Garcia. He asks, UK or European Union have some particular or temporary provisions regarding the failing firm defense regime during the COVID-19 crisis?
So even absent the COVID-19 crisis, both the UK and the EU have got a failing firm framework. So this issue often comes up, came up in the financial crisis, it comes up in normal business concentration. So there is already a starting point as to how failing firm defences do operate. And there is no reason in principle why that isn't fit for purpose in the current environment. And the statements by both regulators have reasserted their standard approach to failing firm defences, albeit slightly more nuanced. So there is by no means a need to reinvent the wheel by saying we need to have a specific failing firm defence in this area. And it's interesting that just last week the United Kingdom, the Competition and Markets Authority, rejected a failing firm defence in a recent merger, and that was because failing firm defence was not even raised in that context, albeit a background to COVID-19. So there is certainly a reassertion of the general approach where the test is very much one of a modified counterfactual in failing firm defences. So usually we would assess the situation with or without the merger, and that would be the benchmark on which in the UK we would assess whether there is a substantial lessening of competition, and in the EU whether there is a significant impediment to effective competition. In a failing firm or a flailing firm defence, the counterfactual is slightly different and looks at the situation with or without the deal that is under evaluation and asks whether that is the least anti-competitive of other realistic scenarios. So that reflects the fact that usually absent this deal, the target would go out of business, and there is infrequently a number of competing acquirers, or there may not be. So the authority has to assess these alternative outcomes. But even if there is no failing firm defence, we've certainly seen in Amazon, Deliveroo, in Takeaway, Just Eat, how the CMA, for its part, has certainly responded and modified, or at least taken account of an evolving economic situation in light of COVID-19.
Thank you very much, Professor. We have two more questions. The first one is there any authorization for the market players to set agreements that benefit the consumers over the prices?
I'm sorry, could you ask that question again?
Sure. Is there any authorization for the market players to set agreements that benefit the consumers over the crisis?
Okay, so I think this goes back to the comments I made in my presentation. So in common with many competition regimes around the world, when we're concerned with cooperation agreements, the first question is usually, does this agreement restrict competition? And if independent businesses are cooperating on areas which in the normal course pricing or supplies to customers market sharing would restrict competition, because the starting point is that they should compete as independent operators, it restricts competition within the meaning of the law. But then there is an exemption regime which says that if certain conditions are satisfied, that agreement is compatible with the law. And that usually has four elements. Under UK and EU law, you need to establish that there would be an improvement in distribution, that a fair share of the benefits goes to consumers, which I think is the point that's just been made, that the restriction is indispensable, so it's no more than necessary to deliver these benefits, and that there is no overall restriction of competition on a much wider sense. So that's paraphrasing the approach. Now, in terms of the procedural machinery for that to operate, in the UK and in Europe, there is no automatic provision to go to a regulator and say, this is my agreement, now authorise it because it meets these conditions. that ended in 2004, as I mentioned in my presentation. So businesses have to do what is called a self-assessment. They need to take that risk analysis themselves, and they do this with the benefit of legal advice as well as economic advice, but ultimately they take the risk, and they will only find out if that risk was a warranted risk if they are sued or investigated by an authority. During COVID-19, we have seen that both the EU and the UK have moderated their approach, or they have given specific guidelines. The UK will not give an upfront approval or authorisation of these measures, but has given guidance to help businesses self-assess. The EU has signalled that it may be open to give a comfort letter, but this is by no means an upfront authorisation, but is designed to reflect these more challenging times. But it's not an upfront approval or exemption. Upfront approval or exemptions still remain in some jurisdictions around the world, including, for example, in Hong Kong.
Thank you, Professor. And our last question is the UK considering any policy or guidelines related to price control in products such as medical devices?
Okay, so this again is a very, very wide question, and it's not clear to me from the way the question's expressed whether this relates specifically to responses to COVID-19 or whether this is a more general question. And what I would say, a few comments about this, is that the UK's general approach to price regulation is to avoid this unless it's necessary, in the hope that prices are set by market participants. So even in regulated utilities such as energy, water and communications, we have seen a lessening of price regulation over the years. So that is the policy framework in which we operate in the UK, which is we don't typically regulate prices. So when we do regulate, we impose measures which are efficiency driven, which give incentives to businesses to beat price controls and create efficiencies. In the area of healthcare, where drugs are supplied into the national health system, there is a specific framework around the pricing there, which is very detailed and beyond this particular presentation. We have no indication at present of any policy drive to regulate the prices of any form of medical supplies or drugs more generally, or in response to COVID-19 specifically. But the whole area of how medical products and devices are procured in the United Kingdom is a whole webinar itself. But I hope that gives something of a framework as well as a specific COVID-19 answer.
Mm-hmm. Yeah, well, thank you very much, Professor, for answering our questions. I think we have arrived to the end of the session. Thank you to all the attendees to this event, and we hope we have more events like this event with you to share some ideas and to listen to experts in these topics that are really important nowadays. Thank you very much, Professor.
Thank you very much.
Bueno, María, yo creo que podemos dar la sesión por terminado. Muchas gracias a todos.
Así es, Camilo. Gracias, Professor Rab. Thank you very much for your time. Gracias. Gracias a toda la audiencia. En nombre del Arte Moure, en nombre de la profesora Rab, nos estamos viendo en unas próximas ediciones de webinars. Estén atentos a nuestras redes sociales, que allí siempre estamos publicando nuestras actualizaciones. Un buen día para todos. Bye bye.
Bye bye.